Hello everyone, how are you all doing? Hope you're well. If you're coming across this channel for the very first time, you are welcome. Make sure you watch this video till the end. Give it a thumbs up, like, comment, and share. Okay, today I'll be talking about a case relating to migration. It is no longer news, as we all know. A couple of weeks we've been seeing what the UK government is doing regarding illegal migration into the country. They're not taking it lightly. They're dealing with it as a matter of urgency. They are saying no to illegal migration into the country. So this case started since last year, 2024. And it's quite an interesting one. I would say interesting because of the twist involved, which I'm going to share with you. Okay, it involves a Turkish parent with their two kids, age at 9 and 6. Yeah, they are still minor. So they came. They were trying to come into the UK. Probably they put the children on a different boat, and the parents were also on a different boat. I don't know which way, but the bottom line is the kids were able to get into the UK while the children were able to get into the UK while the parents were not able to get into the UK. That happened in July 2024. Okay, I'm just giving you a background story. That happened in July 2024. So as the case may be, the kids are now separated from their parents. The kids are separated from their parents. They've been in the UK since July 2024, and the parents, the attempt to enter into the UK failed, so they were not able to reunite with their kids since 2024. So fast forward to that happened in July, as I've said. Fast forward to August. They now August 2021. Okay, 2024. The parent now thought it wise to put an application through to the Home Office, to pull an application through to the Home Office, stating their case that their kids are already in the UK, and the UK government doesn't joke with children. No, it is they stated a code. The article of 3 and 8, section 55. Okay, to support their claim to reunite with their children. But guess what? The Home Office, turned down the application. The Home Office turned down the application, and they saw that, oh, the case is the application is becoming too long. It's not in their favor. They decided to take it over to the judiciary. The parents take it to the judiciary. Okay, so the first twist here is that the judiciary, initially the interim order was granted by the upper tribunal that fine, they can join their children. Okay, that was the initial, but it was an interim decision. Okay, but guess what? The Home Office thought it wise to challenge that decision. The Home Office challenged that decision, that no, when we look at it, they also stated their case that if this was granted, some people might want to take that route as well, sending their kids and then using that oh, the kids, they'll be using their kids to get into the country. And number two, they said that because the safety of the children, that how will you put children in a small boat just so that you relocate? And number three, they said that fine, the parents are now presently in France. France is a safe country. Why not sending back the kids to join the parents in France? Because France is safe. Okay, so why do you want to come down to the UK? So the judiciary, they sat again and they said, oh, it might be they saw reasons with what the Home Office, they saw some, they understood the angle where the Home Office is coming from, and at the long run, they agreed with the Home Office. They agreed with the Home Office, and the decision was given. the tribunal refused to consent to withdraw the decision of the Home Office. Wow. So they said, fine, you can take your kids back to France. The decision to allow the parents enter into the UK was refused. Okay, let me quickly go through it with you. The upper tribunal has recently dismissed a judicial review action involving a Turkish Kurdish family who were separated when attempting to cross the channel. You know, the parents and the kids, they wanted to enter into the UK through the channel, but the kids were successful while the parents were not successful. Okay, so this case concerning parents seeking to reunite with their young children age 9 and 6, the kids are still age 9 and 6, who are already in the UK at the moment. As at when the case was held, the kids were in the UK. The family was separated during an attempted channel crossing in July 2024. While the children arriving in the UK and the parents remaining in France. So on 21st of August, the parents made an application for entry clearance to join the children in the UK. No real progress was made. When they put in the application in August, they discovered that there was no progress, you know, and every parent, you'll be missing your kids. For you to be separated with those little kids, you'll be missing them. He said no real progress was made, and because of this, on 30th December, the parents commenced judicial review. You know, they sought solace in the court. They took their case to the judiciary for a review. Okay, for a review proceedings, asking for an order that they may be admitted to the UK, as well as a declaration that the Home Office ongoing failure to admit the parents was a breach of Article 3 and 8 of the Section 55 duty. You know, they have to argue their case before the law courts. So they are saying that the Home Office refusal to deny the children from admitting the parents into the UK so that they will reunite with the children is a breach. Okay, so based on that, an interim order was initially granted by the upper tribunal, but the Home Office successfully challenged this, and the Court of Appeal see the order aside on the Court of Appeal set the order aside on 20th of December 2024. You can see the long time involved since July till 20 December, you know, and it's not as if they on that December they don't know what their fate will be. Okay, so July, August, September, all for the like 6 months, they were not able to see their children. So and the Court of Appeal set the order aside on 20th December 2024. So on 30th December 2024, 4 months after the original application was submitted, 4 months after the original application was submitted, the Home Office issued, unsurprisingly, refusals of entry clearance for the parents. The Home Office refused, you know, the entry clearance. You know, before, you know, the upper tribunal has said, okay, fine, it's fine for them to come in, but the Home Office, you know, the Home Office refused that decision. The Home Office relied on the Court of Appeal decision and essentially argued that they do not want to create a precedent and open a route for children to be able to sponsor parents, as this creates a pull factor and puts more children at risk. So they also submit their case. They also argued that the Home Office argued that if this case pulls through, so many parents will also want to take that route. They will put their children, you know, into the boat to come first. Then they will now put an application to the Home Office that, oh, since my children are here, I have entitlement to join my children. Okay, and then putting those kids on a small boat put their lives in danger. Okay, So the decision was also said that it is in the children's best interest to return to France and be with their parents. They said, oh, since the parents are in France and France is a safe place, it in the best interest of the children to relocate to France, to go to France to join their parents. Appeals were lodged and are still pending before the first tier tribunal. So the tribunal refused consent to withdraw. In early January, the parents sought to withdraw the judicial review action in light of the Court of Appeals decision to refuse interim relief, as well as the fact that there was now a pending appeal before the first tier tribunal. They essentially argued that the action was now academics as interim measures had been refused and that the case could be dealt with by the first tier tribunal. The Home Office disagreed and accused the parent representatives of gaming the system, essentially saying that they were seeking to avoid another negative decision. The Home Office also argued that the case raised an important point of public interest concerning the behavior of smugglers, but also of parents seeking to use their children to enter the UK where they are in a safe country. Okay, we have said that. Although the tribunal did not accept that there had been any abuse in the process, consent to withdraw the judicial review was refused on two grounds. First, the court found that the case raised points of public interest as argued by the Home Office. Second, it found that a substantive decision on the judicial review might assist the local authority in the family law proceedings in terms of the assessment of the children's best interest and whether unification in France is a possibility. On this point, the court made some comments regarding the parents' conduct and how this was perhaps obstructing unification in France. The tribunal refused consent and went on to determine the substance of the judicial review. Lamely did the Home Office breach Article 3 and 8 by failing to admit the parents to the UK. Unsurprisingly, the tribunal largely relies on the finding of the Court of Appeal in dismissing the case. The tribunal gave significant weight into the evidence, but put forward by the Home Office in the Court of Appeal, as summarized by Collins. Witness statements by senior government officials made the point that allowing the parent to enter the UK would create an incentive for smugglers to put more unaccompanied children in small boats. Evidence was also submitted to show that the French government agreed with this position. The tribunal relies on the Court of Appeal's judgment to find that the delay on the Home Office part in facilitating entry for the parents was not unreasonable. You know, the judicial agreed with the Home Office that the time they took for the decision to be made was not unreasonable. Considering the prospect of the family reuniting in France in the foreseeable future. On this basis, the tribunal found that the Home Office had not breached Article 8 by failing to facilitate entry of the parents as public interest consideration prevailed. So the tribunal ruled in favor of the Home Office that they didn't do any wrong by not facilitating entry of the parents into the UK. The tribunal, again relying on the Court of Appeal's assessment, also found that any distress to the children caused by the Home Office inaction did not reach the Article 3 threshold. So the conclusion of this case is this. In terms of the merit of the case, the tribunal decision does not add much to the earlier Court of Appeal decision on interim measures. What is quite significant about the case is the fact that the Home Office wanted to make a point in court and they succeeded. They wanted to prove a case before the court that if this decision pulls through, people will also put their children forward in small boats coming to the UK, and they'll be using their children to for entry, and the Home Office is saying no to that because they might also be putting the lives of these children at risk. The tribunal's decision focuses on the line set out by the government, namely that if you let these parents in, smugglers will start putting unaccompanied children on small boats. Although the Court of Appeal acknowledged that the Home Office evidence on this point was no doubt speculation, the Court of Appeal said this was just a mere speculation. Ultimately, both the courts and tribunal seem to have considered this as the most significant factor in both decisions. The government arguably took a risk by pursuing litigation up to this point, where they could have quietly allowed the parent to enter last summer. Instead of putting it up all out, they could have just quietly allowed the parents in. But this seems to have paid off, as both the court and tribunal agree with their line. They also managed to get some positive coverage in the Daily Mail. On the other hand, although reunification for this family in France now appears to be a more realistic possibility, the fact remains that these young children have now been separated from their parents for more than 6 months, and they are unlikely to see their parents again in the immediate to medium term future. That's the case. The parents, they wanted to join the children, but the Home Office is saying no to it. So what do you think of this decision made by the Home Office, the decision by the tribunal? What do you think? The tribunal agreeing with the Home Office decision to deny the parents from coming into the UK? Do you think it's fair? So leave me a comment till I come away again. Stay safe. God bless you. Bye.